Welcome back. We continue with Order 7. Order 7, Rule 12, Procedure on Rejecting Plaint. Just like how we had read about it, returning of plaint. Same way, procedure on rejecting the plaint. The court has to give due reasons as to why the plaint was rejected. Okay. Then Rule 13, where rejection of plaint does not preclude presentation of fresh plaint. What do you mean by does not preclude? That means what? It doesn't mean that just because the plaint which has been instituted, which was filed by the plaintiff, it got rejected in one court, doesn't mean that the plaintiff cannot file the case again. Okay, so it does not preclude. That means what? It includes. Okay, so it doesn't prohibit the plaintiff from filing a similar suit before another court at any further time. Okay, just because plaint has been rejected doesn't mean that the plaintiff cannot file the case on the same grounds between the same parties again. So there is no res judicata. That is what it is. Okay. Then next we go to the next subheadings. Documents relied on in plaint. Rule 14, production of documents on which plaintiff sues or relies. Usually what we do, whatever are the documents that we rely upon, right, or based on which we have filed this case, we have instituted the suit. Okay, those documents will be filed along with the suit itself. Okay, if I am filing a plaint, along with that I will produce all the documents which are in support of the plaint. Suppose I miss to do that, then we go to sub rule 2. Okay, where any such document is not in the possession or power of the plaintiff, he shall, where possible, state as to in whose possession the document is. Wherever I have all the documents, I will immediately annex it and give it to the court. But where it is not in my possession, it is not in the plaintiff's possession, then if he knows where the documents are, then he shall state in the plaint as to where the documents are. Okay. Sub rule 3, a document which ought to be produced in court by the plaintiff when the plaint is presented or to be entered in the list to be added or annexed to the plaint, but, underline but is not produced or entered accordingly, shall not, without the leave of the court, do it at a later stage. Shall not, without the leave of the court, be received in evidence on his behalf at the hearings of the suit. Okay. So that means what? Where it has not been produced beforehand, nor has a statement been issued by the plaintiff saying that it is not with me, it is with so and so person. The evidence has not been produced by the plaintiff. There is no statement that it is in some other's possession. Nothing is there, but still he doesn't produce the evidence. In that case, only the court can allow the documents to be presented before the court at a later hearing. If the court allows, then no problem. So before filing the evidences, the plaintiff has to file an application before the court saying that I could not produce it at the earlier stage, so please allow me to do it now. Okay. Then rule 15, it has been omitted, but we'll read the heading. Statement in case of documents not in plaintiff's possession or power. Why it has been omitted? It has been included in the previous rule, right? Rule 16. Suits on lost negotiable instruments. Where the negotiable instruments are lost, but somebody owes a liability to the plaintiff. Okay. So negotiable instrument means what? All of you know Negotiable Instruments Act. It includes check, DD, am I right? So all those, whatever are the negotiable instruments, everything. But suppose the negotiable instrument on the basis of which the liability has arisen, suppose that negotiable instrument has been lost, then does it mean that the plaintiff cannot sue? No. The plaintiff can sue the defendant even if the negotiable instrument based on which the suit is given is lost. Okay, but the plaintiff has to give an indemnity saying that this is the amount and this is what it is and it is truly lost. Once it is, once I find it, I will give it to the court. Okay, but if only there is an indemnity given by the plaintiff, the court can take up the matter and give a judgment as if the lost negotiable instrument was produced before the court or its copy was produced before the court. Okay, but what is important is indemnity should be given by the plaintiff regarding the negotiable instrument. Then rule 17, production of shop book. See, shop book, everything cannot be, the entire book cannot be brought to the court. Am I right? Because some people will have, now of course everything is computerized and digitalized and all those things, so it's okay, right? But earlier what used to happen, there used to be such big book of accounts. Okay, can the entire book of accounts be brought? It cannot be brought to the court. So what should be brought to the court? We have read it in Evidence Act as well. Am I right? So what should be brought to the court? The part where the entry is being questioned, okay, which shows the cause of action. That particular part of the book, account book, if it is shown, that is sufficient. Okay, then in that that is the shop book. Then you have the sub rule 2 in that, original entry to be marked and returned. See, where the book of accounts has been brought before the court, whatever are the relevant entries and the relevant pages. Am I right? So if it is brought before the court shall mark all the originals, saying that hereby it is taken as the evidence has been accepted and it is marked as annexure 1, 2, 3, whatever it is. Okay, so that shall be written down and the original shop book shall be returned to the, whatever is the portion, it shall be returned to the plaintiff. Copy shall be retained. And next we go to rule 18, which talks about inadmissibility of document and not produced when plaint is filed. This we have already read. Even though the documents have not been produced at the time of filing of plaint, it can be produced at a later stage with the permission of the court. Am I right? So rule 18 has been omitted, but we already know the provisions regarding that, right? So we don't have to worry about it. Next we go to we go to order 8. What does order 8 speak about? Order 8 speaks about written statement, set off and counterclaim. We already read, again we go back to order 6, which spoke about plaint and written statement, right? So order 8 deals with written statement, set off and counterclaim and the provisions related to that. Order 8 rule 1, written statement. What is a written statement? It is the defense which the defendant writes in his favor, number 1. It also mentions whatever are the actual facts which the defendant wishes to intimate to the court. Understand? So it is not plainly saying that this is wrong, that is wrong, what the plaintiff has written is wrong, what the plaintiff has written is false. Plainly writing all these things doesn't amount to a written statement. Written statement should also contain facts and the reasons for the denials. Okay, denials of the allegations made in the plaint. So reasons also should be written, plus whatever are the facts which the defendant feels that the court should know, all that will be written down in the statement, plus the evidences to be produced, that shall also be written down by the defendant in the written statement. It's basically a defense claim. Okay, then the defendant shall within 30 days from the date of service of summons on him present a written statement, provided that where the defendant fails to file the written statement within the set period of 30 days, he shall be allowed the same when specified by the court for reasons to be recorded in writing which shall not be later than 90 days. So what is the time period fixed for filing of written statement? Basically, it is 30 days from the date of service of summons on the defendant, right? If he is unable to file it for any valid reasons, then it shall be postponed. Then time can be extended. It shall not be postponed. Time can be extended up to 90 days from the date of service of summons. Okay. Then next we go to Rule 1A. Duty of defendant to produce documents upon which relief is claimed or relied upon by him. As I already told you, written statement will not only consist of denials of the allegations given by the plaintiff, but also mention of the facts and circumstances of the case which the defendant feels should be informed to the court. Understand? So in that the defendant shall also produce documents, whatever are the documents that he needs, that shall also be produced before the court. Okay. Then next we go to, in that itself you have sub rules. Sub rule 2, first one we can go through. Sub rule 1, where the defendant bases his defense upon a document that he relies upon. So whatever are the documents, it can be for set off, or it can be for counterclaim, or it can be plain denials, but all these documents should be given before the court. Okay. Sub rule 2, where any such document is not in possession or power of the defendant, he shall wherever possible state in whose possession or power. Just like how the plaintiff has the right to say where the evidence is. It's not in his possession, it is in somebody else's possession. Same like how the plaintiff has the right, same way the defendant also has the right. Then sub rule 3, a document which ought to be produced in court by the defendant under this rule but is not so produced shall not, without the leave of the court, be received in evidence on his behalf at the hearing of the suit. Same thing what we read for defendant. If it is not produced in the beginning of the suit while giving the written statement, then only with the permission of the court it can be given at a later stage. Otherwise it cannot be given. Rule 4, sub rule 4. Nothing in this rule shall apply to documents produced for cross-examination of the plaintiff's witnesses or handed over to a witness merely to refresh his memory. For these two purposes, where it is given to the witnesses for refreshing his memory or for his information, then such documents are not necessary to be produced before the court in the beginning of while filing the written statement itself. Okay. Rule 2. New facts must be specifically pleaded. As I already told you, it is not just the denials of the allegations of the plaintiff, but whatever are the facts which need to be informed to the court, which the defendant feels should be informed to the court, that shall also be written down in the written statement. It should be specifically stated. It is not only the denial but also look at the circumstances, Your Honor. Okay, so these shall also be stated. Then rule 3, denial to be specific. We cannot just say whatever is mentioned in para 1 is may be treated as false or untrue. Okay, or put to strict proof of the same. This cannot go on like this. There should be a specific denial. Specific denial means what? There should be a reason that is attached to the denial. Okay. So, for example, if the transaction has taken place somewhere near outskirts of Bangalore, since from many states you are watching the video, we would not like to name any places since you will not be aware. Suppose the transaction has taken place somewhere in the outskirts of Bangalore. Plaintiff has written that it has taken place within the city of Bangalore. Okay. Then in the city, in the sense within the interiors of Bangalore. Okay. So in that case, the defendant has to specifically say. He cannot say, no, whatever is mentioned in para 2 is false. That's not enough. Why it is false? Or can he add any value to that particular? whatever is stated in para number 2 is false. Okay. Why? Because he will not write as because, why and all those things. But what will be written down is only that it is false since the transaction took place in the outskirts of Bangalore. So that entire explanation should be there. Okay. Then next we go to rule 4. Evasive denial. What do you mean by evasive denial? Evasive means what? Evasive means very avoiding something, right? So avoiding, evasive, escaping, that is known as evasive. So when we are giving a denial, we have already read in rule 3 that it should be specific denial. No, I am specifically denying this fact. Okay, and there should be a particular explanation to that particular denial. It cannot be very evasive. I don't know. I don't think so. All these vague sentences should not be there, and just like that we cannot say whatever is stated in para number so and so is false. Okay, so whatever is evasive, we cannot escape from the denial. We have to be specific about it. Then rule 5, specific denial, which we have already done. Sub-rule 1 in that says every allegation of fact in the plaint, if not denied specifically or by necessary implication or stated to be not admitted in the pleading of the defendant, shall be taken to be admitted. So where it is not specifically denied, suppose I have missed out denying one particular paragraph, then it shall be automatically assumed as if it is true. Okay. Sub-rule 2, where the defendant has not filed a pleading, it shall be lawful for the court to pronounce judgment. Service of summons has been done on the defendant. Sufficient time, we have seen 30 days to 90 days. Suppose that time has also elapsed, but the defendant has not given sufficient explanation as to why he has not filed the written statement. Even then, okay, he has not filed the written statement, then the court has all the rights to pronounce judgment. Sub-rule 3, in exercising its discretion under the proviso to sub-rule 1 or under sub-rule 2, the court shall have due regard to the fact whether the defendant could have or has engaged a pleader. First, it has to be seen whether the defendant has engaged an advocate or not. Why is it so? It is important because not everyone knows all the subjects. Am I right? So obviously the defendant may not know what is written in law. Okay. So while saying that, okay, you cannot file a written statement anymore, come on, let me go and write a judgment. Before coming to the decision, the court should see whether a pleader has been appointed or not. Understand? Then sub-rule 4, whenever a judgment is pronounced under this rule, a decree shall be drawn up in accordance with such judgment, and such decree shall bear the date on which the judgment was pronounced. Where the judgment has been pronounced, because the defendant has not represented himself, he has not filed the written statement also, then the date of the judgment and what was the judgment and the decree, all the three shall be mentioned. We go to rule 6. Particulars of set-off to be given in written statement. We have already read what is set-off, but wherever there is a set-off which is supposed to be adjusted, okay, the details of the set-off shall be specifically written down in the written statement. What does sub-rule 2 say? Effect of set-off. The written statement shall have the same effect as a plaint in a cross suit, so as to enable the court to pronounce a final judgment. What is a cross suit? I am filing a case on behalf of my plaintiff. Okay, what does the defendant do? He files a suit based on the same thing, saying that, see, he has filed a case for, let's take the same example. Plaintiff has filed a case against me for 70,000. Okay. Now, instead of writing in the written statement, what does he do? He'll file a suit saying that, no, the plaintiff owes me, the plaintiff owes me 50,000. Now, this 50 and that 50 actually has to be set off. Okay. But what does the defendant do? Just like that, he files a suit saying that the plaintiff has to pay me 50. Now this 70 and that 50 matches, right? That's cross suit. So instead of having another suit by the defendant can put forth that particular point of set off in the written statement itself. Okay, so final judgment can be passed by the court. Rule 6A. Counterclaim by defendant, where the plaintiff says, no, defendant has to do this for me. And then the defendant comes out and says, no, the plaintiff also has a liability towards me. And it cannot be set off. It is not in the manner of a set off. Okay. It is in the manner of claiming against each other. So in such a case, counterclaim, there has to be a mention of it in the written statement. We will go to that. Subrule 1. Defendant in a suit may, in addition to his right of pleading a set off, by way of counterclaim against the claim of the plaintiff, any right or claim in respect of a cause of action accruing to the defendant against the plaintiff, either before or after filing the suit, but before the defendant has delivered his defense or before the time limited for delivering his defense. So it should be mentioned in the written statement. Just like how set off is mentioned in the written statement, same way counterclaim should also be mentioned in the written statement. Subrule 2. Such counterclaim shall have the same effect as a cross suit. We have already read that, right? So where a written statement gives the details about the counterclaim, it shall be treated as if there is a cross suit against the plaintiff by the defendant. Okay. So that point, what the CPC means to say is, even that point shall be considered while delivering a judgment. Understand? While appraising the facts of the case, the judge will look into this also and then say, okay, defendant too has a claim against the plaintiff. Subrule 3. The plaintiff shall be at liberty to file a written statement in answer to the counterclaim of the defendant. So because it is in the nature of a cross suit, am I right? It is in the nature of a plaint by itself. Therefore, the plaintiff shall be allowed to file a written statement against the claim of counterclaim. Rule 4. The counterclaim shall be treated as a plaint and governed by the rules applicable. That's why written statement is allowed by the plaintiff, right? Rule 6B. Counterclaim to be stated. Again, it has to be stated specifically in the written statement. Rule 6C. Exclusion of counterclaim. Where a defendant sets up a counterclaim and the plaintiff contends that the claim thereby raised ought not to be disposed of by way of counterclaim but an independent suit. The plaintiff may at any time before issues are settled apply to the court or for an order that such counterclaim shall be excluded. See, we have seen that counterclaim should be written down in the written statement and that shall be treated as a cross suit, right? But where the plaintiff feels that it should not be included in this case itself, there has to be a separate case for that particular counterclaim. In that case, he can file an application before the court saying that this should not be treated as a counterclaim, but it should be treated as a separate cause of action and hence a separate suit is needed for this particular counterclaim. Okay, in that case, there shall be an application based on which the court shall pass its orders. Rule 6D. Effect of discontinuance of suit. If in any case in which the defendant sets up a counterclaim, the suit of the plaintiff is stayed, discontinued or dismissed, the counterclaim may nevertheless be processed with, even though the plaintiff's suit has been stayed or it has been discontinued or it has been dismissed. Counterclaim as a separate cause of action shall still continue to be proceeded against. Why? Because we have already read. Counterclaim is in the nature of a cross suit. Simple. You remember that, you will understand everything. Rule 6E. Default of plaintiff to reply to counterclaim. If the plaintiff makes default in putting in a reply to the counterclaim made by the defendant, court may pronounce judgment. Just like how if the defendant doesn't give the written statement, court can pronounce judgment. Am I right? So same way where the plaintiff does not give a written statement to the counterclaim, court may pass a judgment. Rule 6F. Relief to defendant where counterclaim succeeds. Again, we go on the basis that counterclaim is a cross suit. So where there has been a counterclaim laid by the defendant, that shall also be proceeded against, and the defendant shall the defendant shall get a judgment in favor of him for counterclaim. Okay, if the court feels so, of course. It cannot be just that because I have raised a counterclaim, I will be given a judgment in favor of myself. No. Then Rule 6G, rules relating to written statement to apply. So wherever the plaintiff is allowed to give a written statement to the counterclaim, the same rules of written statement, if filed by the defendant, shall apply to the plaintiff as well. Okay. Then Rule 7. Defense or set off founded upon separate grounds. Where the defendant relies upon several distinct grounds of defense or set off or counterclaim founded upon separate and distinct facts, they shall be stated as may be separately and distinctly. Where the cause of action is also different. Okay, the set off and counterclaim are also different. Then it shall be mentioned separately. Okay, if there are a series of transactions but they are not related to each other, but the parties are the same. Okay, then it can be mentioned as separate causes of action and separate counterclaims can be written down against them. Okay, we shall stop with this. We'll continue in the next class. Thank you.